Welcome, everyone. Thank you for joining us for today's webinar on the EU Whistleblower Protection Directive. My name is Florence Sumare. I'm the VP of Marketing Communications for ECI. And I have the pleasure of introducing our speaker. So today we have Asha Palmer. She's a Chief Ethics and Compliance Officer and the Executive Vice President for Convercent by OneTrust. And just to give you a little background, her expertise lies in the areas of program development and enhancement, training and engagement, anti-bribery and corruption, risk assessments, and third-party management. She has developed and enhanced ethics and compliance programs for more than 20 companies worldwide. And as a former assistant United States attorney and litigator, she is passionate about training, engagement, and finding practical ways to embed ethics and compliance within businesses and with its leaders. She is also an active in the ethics and compliance community worldwide and has presented at Compliance Week Europe, and it currently participates in the well-renowned program for corporate compliance and enforcement at New York University. So without further ado, everyone, welcome Asha.
Thank you so much for that, Florence. I see the chat is already active and going, so I'm very glad to see everyone, although right now all you probably see is me, and to have this conversation with each of you. And just a reminder that this really is a conversation. I know it's just me on camera, but we can use the chat function to talk, to ask questions about anything that I'm saying, anything that you want to discuss. I am here to have this conversation with you, as well as I hope you learn something about our topic today. So what are we talking about today? Today we are talking about the EU Whistleblower Protection Directive. And I see there's people from all over: Argentina, Hawaii, Spain, Belgium, a lot of EU companies, as well as a lot of people from around the world. And so, again, I really hope you get something about the EU Whistleblower Protection Directive, something that you may not know or want to know. Please ask it. And, I think the question a lot of people have is whether or not the EU Whistleblower Protection Directive applies to you or your company. So I hope to answer that question as well as a few more here today. So the EU Whistleblower Protection Directive, as you know, the biggest word in that directive is protection. This directive, which was enacted on October 25th of 2019, was intended to do just that. It's intended to protect whistleblowers. It is intended to increase the transparency and visibility of our practices within our companies to whistleblowers. It is intended to prevent and avoid retaliation. And so when we go through these slides about kind of what is in this directive, understand that the intent is just that. It's not about us or the corporations, but it really is about the human beings that are behind whistleblowing and the human beings that speak up so that we can uncover things that are illegal or unethical. So with that, I'm going to share my screen and take you through what exactly this EU directive requires. So hopefully you can see that slide. Again, as I go through this, just remember this is not legal advice. It is just for informational purposes. And so to the extent you want to know whether you're in compliant or otherwise with the directive, we do suggest you talk to legal counsel. So I started a little bit on this before. Why did the EU Commission decide to enact the directive? There is a report that is actually available on the website of the EU Commission that they considered, and it's about a 75-page report about the dire state of whistleblowing laws, across the EU member states, as well as the dire state of retaliation across member states. And that is really the basis of why the EU Commission came up with this directive. They wanted to see greater consistency across member states. They saw that some member states had whistleblower laws and some didn't. Some offered certain protections and some didn't. Some had different burdens and fines and others didn't. And some had nothing at all. And so the Commission wanted to make sure that whistleblowers across the EU were protected and that there was consistency across the member states in how they were protected. They also wanted whistleblowing protection and laws to extend beyond employees. Many of us here are probably internal facing practitioners. So our focus of our program is usually, right, employees, the people we work with, our boards of directors, but it's really the people within our organization. The Commission really wanted us to extend that scope. They acknowledge that there are people outside of your company that may have knowledge or information about breaches of EU laws, breaches of national laws, or serious misconduct. So they really wanted to make sure that those individuals were empowered to speak up as well. And then really to prevent retaliation. As I stated before, retaliation, as we know, is a huge issue. And it's a huge barrier to any of us building trust within our organizations and in our programs. We know that if whistleblowers fear retaliation, then they're not going to speak up. We know that whistleblowers have been retaliated against, so they don't speak up. And so really the intent of the directive is, how do we solve that problem so that we encourage people to speak up and protect them from retaliation? And then lastly, one of the big intents of the directive is to protect the reporter's identity. Many of you who are in the EU or do business in the EU already know that our personal information is protected under GDPR. But what about our identity for the people that are able to access that information? And so the directive really wanted to make sure that people who had information about the reporter's identity were able to protected that in a way that prohibited access from non-authorized individuals and protected that information. Okay. Under the directive, the Commission really outline 10 areas in which a whistleblower can speak up. These are the 10 areas that are in the directive that are listed as to what breaches of EU law are covered under the directive. So as you see here, some of these are traditional areas that we are able to that we've seen people whistleblow about before, right? And some are not necessarily traditional. But if we remember and go to the intent of the Commission, it really was to uncover breaches of EU law. And so these are the areas of EU law which the Commission was mostly concerned about. What we're seeing, however, and we'll go into what the member states are doing about it, is that they are extending the scope of what whistleblowers can report under the directive. And I want to pause for a second and just level set, because what does it mean to be a directive? Being a directive and not a regulation is a very important distinction for this law. So, unlike a regulation, and maybe you know this already, but a directive requires the member states to then individually transpose it into law. A regulation is already law in which must be applied across the member states. So example, as we were just talking about, GDPR, it's a regulation, applies across EU member states. Directive requires each of the member states to individually transpose laws that are aligned with the directive. So what we see in the transposition in various member states is to expand the scope of what whistleblowers can report on. Okay, let me go to the next one. Now, the other thing the directive does significantly is talk about who can be a whistleblower. And I mentioned this in the why behind the directive. The directive really expands the scope of who can be a whistleblower to current and employees and all of that. Hold on, I'm going to try to mute my notifications so that they don't come on. Okay, I think I did it. And let me make that bigger. Okay, there we go. So who can be a whistleblower has expanded. Again, like I said, we focus mostly on internal employees. What the directive says is they want us to make sure that people outside of our organization are able to report on the directive. As I say in jest, they want to make sure that everybody and their mama knows that you have a whistleblower process helpline and that they can come to you and report breaches of EU law. You will see the expansive nature of who and what can be a whistleblower. And so it's really important to understand that it is now our obligation to present the information about our helpline or hotline to these individuals. And we'll talk about that a little bit more. Okay, who does the directive apply to? This is a very, very important distinction that is kind of a bit nuanced. So what happened, the directive was enacted, as I said, on October 23rd of 2019. Under the directive, it required member states to transpose a law by December 17th of 2021. And many of you are correct that December 17th, 2021 has passed. And I believe someone has already pointed out in the chat that many of the member states have not met that deadline, including Chris, who outlined that Poland has not quite met that deadline. And that is true. Many of the member states, there are only 5 member states that have implemented it to date. And the rest of the member states have some kind of draft or otherwise. And we actually at Convercent by OneTrust have a really good resource on our website that can go through which member states have implemented versus which have not. But what the directive says, and what we see most member states transposing, is that companies, public and private, with 250 or more employees have to have certain mechanisms within their organization to comply with the directive. So basically, these obligations that I'm going to go through after this apply to people or companies. And I say companies, the wording in the directive is legal entity. So I know many of us, wherever we do business, may have a legal entity in the EU. If that legal entity has 250 or more employees, then as of December 17th, 2021, you need to have these protections and mechanisms in place. And Chris, that's a great question. If there's no member state implementation, what does that mean? And it really, what we are advising many of our customers who are asking us that exact same question is that they should implement the baseline of the directive, because what we know is that the member states, for the most part, won't go under the threshold, right? So the directive is a floor, but not a ceiling. And so our advice to people, even though your member state hasn't implemented, is to, one, go and look at what the draft may say, because many of them have drafts out. And then 2, kind of think about what the directive says in general and implement some of those baseline items, but maybe not revise your policies and procedures internally until you see the final law. And then again, there's another category of employees that have 50 or more employees that most member states have to are requiring you to implement by December of 2023. There are some nuances there, so please check the member states that you do business. I know, just for example, like Czechia has a threshold of 25 employees that companies have to comply with. I know that Sweden has changed the date to July 17th of 2022 for all companies 50 or more employees to comply. So there are some various nuances there that I would suggest looking into. Okay, what the directive also requires are us as internal practitioners and as companies to let the whistleblower know that they have 3 options of reporting. And I know this may be a little surprise to some people, but you have to let the whistleblower know that they can report internally, externally, or to a public office. And I even would subdivide the internal channels to something we're going to talk about, which is whether a whistleblower can report locally or whether they can report to a centralized helpline. So that's one avenue. Then there's the external channels, which many of the member states' laws are identifying the external entities or agencies that will handle whistleblowing complaints under here. So I'm just giving examples. Say it's the Department of Transportation. All complaints issued under here, if you don't want to go to your internal channels, go to the Department of Transportation. Or you can go to the media. And now the onus and the obligation is on us to let the whistleblower know that they have those options. So interestingly, what it hugely incentivizes is our ability to build trust in our programs so that people do come to us and not directly to the organization. So let me see. There are a few questions. Let me just answer. For all EU, we have close to 250 employees, but well under 50 employees in each country. So for that, Chris, quite frankly, the EU Whistleblower Directive does not per se apply to you. That said, the Commission has not been vocal about whether or not, if one of your employees goes to, say, again, that Department of Transportation or whatever that external channel is that is available to them, whether they go to them because you don't provide sort of internal reporting channels, whether that person would still be protected. And my thought is, just based on the intent, and this is just Asha speaking, I have nothing to base this on, but I think the intent, again, is to protect the whistleblowers. And so where you think about employee count, that could be your threshold, but also think about risk or blind spots or vulnerabilities with or opportunities to connect with the individuals in those countries. And maybe you set up a helpline or a hotline that encompasses all of them and is able to be met in their native language. And then it says, there's another question about what happens if a legal entity has various branches in the EU? Does the directive apply at the branch level or the legal entity level? I don't know the per se answer to that question because there's not a definition of legal entity, but it does say separate legal entities have to have these channels. So I would say the legal entity level. If no implementation or transposition has expired, wouldn't it be possible for citizens to rely on the direct effect of the directive? Technically, I believe the answer to that is yes, that they would still be entitled to the protections of the directive. I'm just not sure who the suit would be against. It might be against the country and not the company for failing to implement and then not having the directive. But I think in principle, yes, it's probably something that we could expect. It would just be a very complicated legal proceeding or action. Okay. The directive says you need to have internal reporting channels. And we will talk about this, the hot topic under the directive, which is the local versus the global implementation of reporting channels. The directive actually has an or in the type of reporting channel that you can provide. It says oral or written or like a mailbox and so it doesn't mandate that you have multiple forms. But the interesting thing about it not mandating what the reporting channel looks like or how it presents itself, but the directive does require certain protections for that channel to have. So let me give you an example. If you choose an oral reporting channel, so say an individual, say they're coming to Asha, and I'm the local reporting channel, I have to make sure that that channel, so me, is GDPR compliant, is only accessible to authorized employees. So that would also mean probably my email account and all of those things, where I put the information, where I store the information. It has to make sure it's secure and confidential. So when you think about the holistic picture of what the reporting channel has to have, is an important factor in what reporting channels you choose. The other thing I will add to this slide is that it has to be available externally to all of those people on that who slide. So when you think about it, we did a bunch of road shows across the EU on this exact topic. And some people say, well, I'm just going to put a mailbox, on site that people can drop a letter in and then I'll be compliant. Well, the problem is that that mailbox is not accessible to many of the people who are allowed to be whistleblowers, or who now the directive wants to make sure are able to be whistleblowers. So that likely wouldn't be seen as compliant. So thinking about how you present whatever reporting channel you do, just make sure, again, the channel complies with the security and confidentiality requirements of the directive, as well as who it has to be available to as well. Okay, sorry, get over here. Okay, what does it say about the case management process? One of the very interesting things that is huge change management for us is that the directive requires certain specific communication requirements. So it requires that you acknowledge receipt of the report in 7 days. It requires that you give resolution or feedback within 3 months plus the 7 days under the directive. It requires, it says this multiple times, but doesn't quite define it, that it requires diligent follow-up. And so what that means, again, not defined. However, again, thinking about, and I'm a litigator by trade, so thinking about if you were in front of a court of law and you had to say, I diligently followed up with that individual, what would that look like? And ensuring that diligent follow-up. And again, one of the things you'll see in the underlying report that came before the directive is the comment from whistleblowers that their reports went into a black hole. And I'm summarizing, but it went somewhere and it was never to be seen again. They didn't hear from anybody. They don't know what happened. Nothing happened. And so they went to an authority or otherwise. The directive is trying to say, we need to communicate with the whistleblower. They need to know what's happening with their case. They need to understand what's happening with their case and agree with it. And not every step of the way. So there's no obligation in the directive that says, we have to tell someone if we interview their manager, or we have to tell somebody if we do this. There's none of that requirement, but the only requirement it does add is that the whistleblower must be given the right to review, approve, or edit their interview notes. So that is, to me, a change management function. I've never seen a law require that, but I understand why, right? Because they want to make sure that before we go on the investigation, that we've gotten an accurate account of what the whistleblower is saying is happening and that we're investigating the right things. Okay, let me check the questions right quick. Okay. All right, let me go to the next slide. There's also some data and security considerations that are mentioned in the directive, including complying with the GDPR, which I mentioned earlier. And the law is very vague. I mean, the directive is very vague about that. It basically just says it needs to comply with GDPR. But thinking about, data minimization requirements and things like that are what we also have to think about in whatever local reporting channels and processes we set up. Again, only collecting the necessary personal information required to handle the report, the ability to have secure and confidential reporting channels as well, and then the protection of access to non-authorized employees. That one is particularly important because what the directive, again, if you go back to the intent, it wants to protect the identity of the whistleblower, and it understands that retaliation happens the more people that know about the directive. And so if you think about that, they really want secure and confidential reporting channels so that so that the identity of the whistleblower is protected. Record keeping and retention. There are some record keeping and retention items in the directive that slightly raise an eye to how do you comply with, say, a SAP and DE and the directive. I don't quite have that answer for you. If you do feel like there are conflicting laws between what you have been told about record keeping and retention in your jurisdiction and this directive, then I would either write the commission or write your local authority or have conversations with your legal department to figure out how you adapt your internal processes and procedures to comply with both. But the record keeping and retention policy under the directive does talk about being able to retrieve the reports and to have accurate meeting notes that are kept in a durable and retrievable form. So it also ensures that notes to meetings or minutes of meetings are transcribed in the outcome and investigation report. So I think many of us, will take some notes during an interview or otherwise, but don't necessarily transcribe those or make sure that we keep them in a durable way and add them to the case file. So that is definitely something that is required under the directive. Okay, I talked about this a lot. There is some confidentiality and retaliation provisions in the directive that are, again, meant to ensure the identity of the whistleblower and anyone mentioned in there is kept confidential because, again, it is closely correlated and usually coordinated with retaliation. They want to make sure that the confidentiality is guaranteed, and then really to make sure that there's a mechanism to communicate in confidence with even an anonymous reporter. And then the retaliation prevention. I'll go into that a little bit more in the coming slides, but the directive does something that, to my knowledge, the only member state before the directive that had this provision in place was France. But the directive puts a reverse burden of proof onto us as companies to now show that we did not retaliate against an individual, as opposed to the individual showing they were retaliated against. So we'll talk about that reverse burden of proof a little bit more. The other thing that the whistleblower does, the Whistleblower Protection Directive does, is talks about how we as companies must train and communicate the ways in which a whistleblower can speak up. And my favorite statement, which is why I quoted it in the slide deck, is that we are required to train potential whistleblowers to make informed decisions about whether, when, Yes, whether, when, and how to report. I put those in the wrong order, but whether, how, and when to report. So when you think about that on a holistic basis, if you go back to the original slide of who can be a whistleblower, and then now the requirement that we have to train those whistleblowers so that they understand and can make informed decisions about whether, how, and when to report, that greatly increases the scope and responsibility of our departments. So how do they know what to speak up about? And we do a really good job now about training, our annual training or our just-in-time training or our portals or otherwise where people can get information on the types of things that they're able to speak up on. We do a good job of that internally. What does that mean now to train whistleblowers who could be outside of our organization on these same things? Again, I don't have any answers. We put some pragmatic steps on here to kind of help you think about how you could do that. But that's something for you to operationalize on your side as to how do you really get that message out to whistleblowers, where they can speak up, how they can speak up, and about what that they can speak up. And again, really communicate that. And then again, when I say how to speak up, it's not just the subject matter. It's not just to that wide range of now individuals. It's also educating those individuals that they have those 3 avenues, and I say 4 avenues now, that they can speak up to. The other thing that the Whistleblower Protection Directive really takes into account is who is receiving the cases on the other side. So not just how you get more cases or more people to speak up, but also what happens once those people do speak up. And so it really talks a lot about who is on the other side. Can they speak to that person? Do they understand? Are they competent? Are they independent? Are they anonymous? Have they been trained to handle the type of cases that are coming in? Are they available and accessible to employees? One of the things I didn't previously mention, but the directive actually says this a few times. When you talk about avenues of reporting, whether it's oral or written or those other ones, what it does say is that the whistleblower must be given the choice to have an in-person meeting if they so choose. So it also requires that, say I don't want to go through a portal or a helpline or a hotline, and I don't want to go to my manager and speak up. I want a personal meeting with, the case manager or the person handling it, that they're able to have that in-person meeting. Again, they need to be trained. The person handling needs to be trained in the investigation protocol as well as the handling of the case. And what's interesting about this is that we're going to get into, again, whether local reporting channels or centralized reporting channels are required. When you get down to the local reporting channels, this is so important because it may be something that you otherwise don't have, which is trained staff on the other end of the local receipt of those things. Let me just check the chat to make sure. Okay. Now, how do you educate, and why do we say you should educate the board and senior management? One of the things that we are seeing, and this is not in the directive, we are more seeing this in the local implementation of the directive, is that there are corporate liabilities and fines for failure to implement certain elements of the directive. So, and that corporate liability can exist in the form of fines or in the form of jail time. And jail time for executives. And so when you think about now the potential financial, also reputational, but also individual liability that could exist either from failure to implement this directive or from retaliation, you really want to make sure that the board and the senior management is aware of what's happening here, is educated in it, and knows that it's a potential risk as well as what you're doing to mitigate that potential risk. As you'll see here, we reported on Denmark and Sweden, the two first to the start line of implementing the directive, where you see one has extreme penalties and fines, and the other has none. So there is very much a variance about what people require and what the different member states require. I've talked about this a little bit. We now just have an extended scope. We've got to empower people that we may not know exist, have to find out exist, have never really maybe talked to or have visibility of. We have to get closer to our supply chains so that we can make sure things like their contracts or otherwise really empower the third party to say, if you see it, say it, things like that, to understand that they can speak up too. And here's how to make informed decisions about how, when, and why, how, when, and where to report. Retaliation and the reverse burden of proof. I want to start with how the directive defines retaliation. And there is a very, very, very extensive definition of retaliation that I suggest everybody on this call go and look at. It is a lot of actions, and it extends to a wide range of individuals. So really thinking about hard retaliation, soft retaliation, overt retaliation, subtle retaliation. So we understand what we're trying to prevent, I think, is a very important first step. Here's the list. You can digest it. I obviously won't read it for you. I mean, I see a bunch of people asking for the slides after this. We'll be happy to share them with you. And also we can point you to where on our website you can find any or all of this. It's all in our ebook on the EU directive as well. But retaliation can be a lot of different things. And so first, starting with us understanding, again, what the conduct is that we're trying to prevent is a really good first step for then operationalizing how you ensure that conduct doesn't occur. Here's the reverse burden of proof that I was talking about earlier. And again, only member state I know that has had this in place before is France. But the best way I can describe it, again, because I'm a litigator, is that if you were to be sued by a whistleblower who alleges they were retaliated against, what would be your proof that either you didn't retaliate or that you did everything you could to try to prevent it? So it is now our proof as a company. We will need to sort of particularly collect evidence or information that shows we tried to prevent retaliation, that we followed up with the whistleblower and maybe even other individuals involved in the case or people with knowledge of the case to make sure that there was no retaliation going on. But it is now our burden to make sure that retaliation has not occurred. And so really, what do you do with that, right? I think we see a lot of our customers at Convercent asking, how do I do this? How do I, how do I make retaliation or prevention of retaliation more proactive? And a few just small advice that we give is one, it needs to be more than just a line in your policy that says we prevent retaliation or we have a zero tolerance for retaliation. Maybe retaliation now needs to be on our training agenda, just like conflicts of interest or other subjects are. How do we make sure that people can identify it, know what it is, and know how to prevent it? Can we empower bystanders to help flag it or prevent it or stop it or understand it? It's those kind of things that we can be proactive with to understand. Let me see, I think there might be a question. Okay, wait, let me just check at the top. Okay, it's a question. Is reporting non-action by a board to ensure compliance measures are being taken, protective activity. I'm not sure. I would look if that. First of all, I would look at the directive and what they outlined. So again, the directive is really just focused on breaches of EU law, but what we are seeing in the member state transpositions of the directive is that they are extending it again to national law. And they are also extending it to things that say like serious misconduct or threats to the integrity of the country or something. There's a lot of sort of catch-all phrases that are being used that could maybe encompass something like this as well. Again, for retaliation, it's our burden now and not the organization. And the other thing that the directive does that is new is that it prevents retaliation against third parties. So say a supplier or a vendor or someone raises to you a concern and then they don't get the next contract. I think the difficult part that we're seeing for many of our customers is how do you operationalize that? How do you operationalize in the offboarding of a vendor or otherwise, an understanding of whether this is the form of retaliation? And I think that's a very interesting thing to operationalize. But I think it does start with first the communication of third parties who are either whistleblowers or who are mentioned in whistleblower complaints, and then how you sort of infuse yourself or your process into procurement or whoever's in charge of offboarding so that you're a part of that decision making and process and at least are aware of whether someone would run afoul of that or be able to claim that within the whistleblower. Okay, I think I see maybe a few more questions will come in. Just want to make sure I'm getting to everyone's question. Okay, I think we're okay. Okay, again, I think one of the things that we just have to be mindful as practitioners is once we begin to educate on the reverse burden of proof of retaliation, we want to make sure that we empower whistleblowers to speak up, but that we don't suffer from stage retaliation or someone who wants to be retaliated against wants to claim retaliation as a result of the benefits that come from it. I personally think this is a much smaller risk, but it is something that we need to be mindful of. Okay, I've referred to this a few times, and there's some good shows out here, talk shows that always talk about what is the hot topic. So I figured I'd name this the hot topic. And the reason I named it the hot topic is because it's the one that everyone's talking about. We went on over 28 road shows in last fall across the member states, most of them virtual because of COVID. But we had conversations with practitioners, many of them just like you, who were made aware of a few letters that were written subsequent to the directive about whether a global helpline satisfied the directive. I'll give you just a brief history of what those letters said. The letters basically said that companies with 250 or more employees could not benefit from a global or centralized reporting function. Mic drop. The directive is quite silent about this. The directive says that local entities between 50 and 249 can share investigatory resources with the parent company. It does not say anything about 250 or more. So it basically says they need to have their own channels. So a lot of interest groups from all over the member states wrote the commission and said, what does this mean for us? And in multiple commission letters, and expert working group meeting minutes, which we have combed over and over again, the commission is very clear that if your subsidiary or local entity has 250 or more employees, you have to have both a local intake channel, so that reporting channel that we defined in the beginning, you have to have a local reporting channel, and you also have to have the ability to handle investigations at the local level. This, again, is a big requirement for us, many of us who don't have big staffs or have equipped local handling individuals. And then if you go back to that empowering local handlers, it's what they are able to do on the other side that is also our responsibility. And I'm just going to go through really quickly where the commission made clear that these were requirements. And again, we at Convercent have this information available. We just did our 9th bonus masterclass series on the EU directive on this exact topic. We went through each of these requirements in these letters, but here's the output from all of those letters. Only having a centralized reporting channel if you have over 250 employees does not meet the directive. And the commission was clear about this on 2 occasions. Local, and if you have between 50 and 249, you can benefit from the investigatory, I can't say that word, resources of your parent company or the global company, but you still have to make available a local reporting channel. So basically, regardless of your size, if you have more than 50 employees in any jurisdiction, you will have to have a local reporting channel that is separate from the centralized function. What is different is on the back end, if you have 250 or more, it must at least go to the local entity. If you have 50 to 249, it can go to the global entity. Whew. I know you have to play that back a few times slowly because it is a lot, but that is essentially what the requirement states. How you operationalize that, again, I mean, obviously as a technology provider, we believe the best way to do it is technology, but really having those great conversations within your company to say, how do we operationalize this and do this? I want to give the caveat of number 2. Just because there is a local reporting channel and a centralized reporting channel required does not mean, and the commission is very clear in a letter on June 29th, does not mean that we can't educate the whistleblower about choosing between those 2 channels and also giving them the option to report to either. So you can capture the consent of the whistleblower to say, I want my case to be handled centrally. You need to capture that, however, in any entity that is 250 or more employees. The other thing that I think a lot of individuals are talking about is number 3, which is how do I maintain best practices? So you may be, obliged to, comply with something like Sarbanes-Oxley, or best practices in our industry has always been to have a centralized helpline, right? I know this. I have like my intro said, like Florence said, I have done this at more than 20 companies and now partner with many of our customers to do the same thing. How do you operationalize this local requirement with the best practice that the centralized function or the global reporting channel should have some oversight over it? And the commission is very clear that the requirement to have the local channel doesn't mean that the global function can't have oversight of the existence of that case. So what does that mean? What we think it means, and again, I would verify this with any legal counsel or otherwise, what we believe is that what the directive is trying to protect is the identity and the stuff that would be, say, in the case details section of the case. The who, what, when, where, why, how, all of the juice that came out from the investigation. That case detail, if the whistleblower chooses, should be handled at the local level. It doesn't mean that you as a global function can't still have knowledge that it exists. So for example, in a reporting dashboard or otherwise, you could have knowledge that there's a conflict interest case that was raised in Poland against Asha. Well, you wouldn't know it was against Asha. You would know it was raised anonymously, but you wouldn't know the details about who is involved. You would still have governance or oversight to know whether you have a hot spot or a cold spot or a problem in any jurisdiction. Again, compliant with GDPR, you always have the option of getting the whistleblower's consent to handle it at a central or inform the centralized function of what happened, but you do need to gather that consent and to document it. 4, as I already said, only medium-sized companies can benefit from the shared investigatory resources. So when the case comes in, separate intake channel, sharing those investigatory resources at the global function is something only by default that without the whistleblower consent that you can have if you are a medium-sized company. So 50 to 249. Okay, that is a lot. Let me pause here and just check the questions because I know there are questions. Flora has a case about Convercent modifying its case management system to address these provisions. Of course we are. If you are a customer, please talk to your customer success manager because we have operationalized all of these requirements in our tool. Skip asks, related to this, do you expect that directors and officers' liability insurance will be stepped up to cover claims arising from whistleblower claims and or from failures by executives or board members to do what the directive requires? In my crystal ball, Skip, I say the answer to that has to be yes. I think that is a decision that each company will make based on a risk tolerance level. But yes, I mean, again, in the countries that you do business with, check. We have extensive guides as to whether there are jail requirements or corporate fines in the countries that you do business. And we actually will be releasing checklists of compliance on our website in the next week or so. So you can print and download whatever country you're in, check to be able to do it. Chris says there's a realistic chance that Poland national implementation will be under the floor level of the EU directive. No obligation to take reports from outside company or to provide. Again, will employees be able to rely on the direct effect of the directive? I don't know the answer to that. Again, I think the answer is yes, but just again, thinking about what the intent of the regulation is, which again is to protect that whistleblower. I think that is required. The other thing that we just have to think about as practitioners is, do we want individuals who could be protected under the directive or say in a different member state to go outside of our organization? And so to think about it more, not just as from a liability or risk perspective, but really as an opportunity to uncover or potentially uncover, any kind of illegal or unethical action that may be happening on behalf of our organization that we otherwise haven't empowered ourselves to. And so, yes, this is a legal requirement. Yes, this is going to require some change management. Yes, it may be a pain to figure out how, when, and where to operationalize it, but we're really trying to ensure that our customers look at it as an opportunity to partner with different business units, to partner with your technology provider, to partner with your suppliers, your vendors, your interns, all of those people, so that they know and understand what it is to speak up. They feel the psychological safety behind speaking up, and we're really empowered to uncover kind of things that really matter within our organization and hopefully get ahead of them and remediate them. I know that's the optimistic, altruistic part of Asha that I am, but I really believe that, requirements can be a good thing. And I think this will expand our mind in many ways of doing it. Okay, I just have a few more slides. Just to reiterate, there are extreme nuances between the member states. There has not been one size fits all with any of the member states' implementation of this directive. So I cannot say it enough that you need to go and see where it could apply to you, where it will apply to you. One of the things that I want to mention is a lot of the directive, when you go and kind of compile what member states you do business in and how many employees you may have in those member states, which I highly suggest as a first step if you haven't done it yet, is thinking about, are you close to the threshold? So for example, one of our customers' business units was at like 222. And I was like, does it really apply? Maybe not per se, but are there expansion plans in that unit? Are there this? When are you hiring? When are you? So understanding kind of places where you may do business, where it could cross that threshold is important, because you want to make sure you have the protections in place. And that's kind of the other extreme opportunity that can come from all of this, is when you look across member states, because many people do business in multiple member states. If you are in multiple member states, do you apply the floor or the ceiling? And we are suggesting that you apply the ceiling of what the most stringent requirement is, because then it creates some consistency across. And then maybe you don't even look at the numbers. Maybe you say, I'm just going to implement a technology solution where in all of my EU member states, people have an opportunity to speak up, and there's some type of local reporting channel, regardless of whether it's covered by the directive. I haven't found many customers yet who are there, but we're trying to get people there. This is an example when I told you that Convercent by OneTrust is doing all of the things to try to be a partner with the profession. Really, it's not, these are publicly available resources. They're not just available to our customers. You can go to our website now and download them. But we're really trying to be a partner with you on this journey. I mean, I'm a practitioner, as Florence said. I do this in the company, but also partner, like I said, with a lot of our customers to help operationalize their programs. And so we're really on this journey with you. We're tracking what the member states are doing. We're tracking the nuances and the general nuances that we see, which typically fall in these 9 categories, which are on your screen. I'm just going to flip to Sweden so you can kind of see the difference. And we're really trying to update them as they come out. As we know what the new developments are in the various member states, so that we really can help you ensure that you're compliant, or brainstorm solutions from a technology point that will help you to be compliant with the directive. Again, we don't guarantee your compliance. You need to do that internally with your legal counsel or otherwise, but we do have some ideas that we think are pretty solid about how to leverage technology to not only implement the spirit of the directive, but also to implement it in real time. So with that, I have talked for a full hour. I'm just going to see if there's one more question, which I see on here. When they say external, do they mean we have to advise any and all other entities they can report to, like the SEC or EEOC? So no, under the directive, what it requires is for you to inform people that are in that member state what is the external agency that also handles this whistleblower complaint process. So again, what we're seeing, if you were to read the Danish law, it says, you need to do these things as a company. And then it also says the external agency charged with handling any whistleblower complaints under this law is blah. and that blah is who you have to educate people that they can go to. So it's not generally that they can go to whoever and whenever. The obligation under the directive is to inform them that they can go to another agency within their jurisdiction to speak up on the same issues.
Great. Well, thank you so much, Asha. We really appreciate you and Convercent by OneTrust bringing this important and timely subject to our stakeholders that are all tuned in from all over the world. I think you might have seen them in the chat where they're joining in, and sometimes it's like midnight or something. So again, and thank you for just answering all the questions. I think the natural flow of this particular webinar was great because you got to just answer them fairly quickly and, you know, have the presentation, all the information you wanted to provide for everyone to see. So I think folks had questions on whether the slide deck would be shared, and yes, you did say that it would be shared. We will get that link to all of you, as well as the survey. So very important. We'll give you the slide deck, as well as if you could please fill out the survey. That only helps us provide you that timely and the content that you like and need from ECI. But again, thank you so much, everyone, and Asha and Convercent by OneTrust for being a constant supporter of ECI and our initiatives.
Yeah, thank you. Thank you so much for having us.
All right. Bye-bye. Bye, everyone.